Love and affection, no fear of rejection. This I know is true. Peace and contentment, no need for resentment. This I found in you. This I found in you. Love and affection, no fear of rejection. This I know is true. Peace and contentment, no need for resentment. This I found in you. This I found in you.
Yo, can I with you? What?
ACT, did you see this?
Look, if it ain't official DanaJay, Levi for Kelly, or Prima Donna News, I don't even want to see it. Just take the time. Look, you got some weed? I gotta get some. All right, hurry up. Diesel and them here, everybody here, we waiting on you. All right.
But I know that there's more. More for you, more for us.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
DJ discretion.
Flow still sick, I ain't talking that pandemic.
Say it louder, what you gon' do now? Hope you're ready, cause I'm really about to put it down. Girl, you know that I will never disrespect you. We have tomorrow, but tonight I wanna spank you. That ass down, gotta make it last now. Girl, I'm so think I'ma beat it up.
Yo, what's happening? It's your boy Papa Dub. Be mad at me. Yeah. I tried to tell him. Yeah. Goddamn, my lady pregnant again, but this time she pregnant with twins. Another collection plate. Come on, preacher, that's kind of strange. I'm sorry, God, I need that little change. I gotta do a couple things, cause that stimulus, it ain't stimulate. Tax time, the mama got pissed and won't let them claim the baby. They shooting again. These just crazy, they need some help. Man, they shot him in the hip. He fell out and shitted on himself. My cousin Paul called Fed time. Up the road, did a whole dime. He used to call home. I heard niggas crying in the background. Saying to myself, this ain't how we supposed to live. Turn on Facebook, man, another bitch that got killed. For the love bag, my dog losing weight out here smoking cocaine cigarettes. 8 years old, shot in the head, had nothing to do with that. That baby innocent. Go get George Zimmerman if y'all just wanna kill a bitch. That's why I'm asking Jesus. Please tell me why you leave us. Tell me why you leave. These people wanna dead. On the internet capping, that shit is fake, bro. In the mirror showing your ass, putting no makeup. Man, y'all better wake up. Wake up, wake up, wake up, wake up, wake up. Man, y'all better wake up. Wake up, wake up, wake up, wake up, wake up. Man, y'all better wake up. I've been telling y'all better wake up. You can't nail bitch, say Papa Duck, ain't say nothing. I told y'all everything. I told you I like the government stole it. I told y'all about COVID, the CIA and the cloning. MK Ultra, the whole world's under hypnosis. They turn the TV off, that's how Hollywood control us. And ain't no cure for cancer, you're right, that's some bullshit. If they can lead us and go to the moon, they'd have been undid it. And if you took the shot, I pray for you. Lord, no. Don't want black folk to grow, so they put us on birth control. And just cause you go to church every Sunday don't make you saved. 12 years of school's how you turn niggas to slaves. On our minds they put shackles, they lie, trickers and trappers. They use the influence of athlete, actors and rappers. For real, that fucked up they did to Emmett Till. And all the pain his mom and family had to feel. That's why I'm asking Jesus, hey, please tell me why you leave us. Tell me why you leave. These people wanna dead. On the internet capping, that shit is fake, bro. In the mirror showing your ass, putting no makeup. Man, y'all better wake up. Wake up, wake up, wake up, wake up, wake up. Man, y'all better wake up. Wake up, wake up, wake up, wake up, wake up. Man, y'all better wake up. What's happening? It's your boy Papa Dub. I've been telling y'all about this shit for a long time, bro. I get on YouTube every day, drop videos on nothing but that sauce. And I'm telling y'all what time it is. And I'm telling y'all, these people want us dead, bro. We living like it called to do this and bro. I done been wide open just to hate and hurt and kill each other every day. You feel me? You feel me? Man, one time for all the folks that's already woke. The ones that ain't, need to wake up. Need to wake up.
What's going on? What's going on? I'm sitting up here watching this. I'm watching these pictures, right? Shout out to the Dream Team and everybody there. First, I want to say this because I was about to get into it. First, I want to say shout out, and I want to send a shout out to the people that has donated so far. I went from 65 to 62. I need 62 more people to donate between now and Saturday. With $45 if you can. I really appreciate it. Y'all see it going across the bottom of the screen. However, I got some issues, man. I got some issues. I'm looking at these pictures, right? Of this thing that they call monkeypox. And if you see me rubbing my arms because it's nasty, it make you itch. However, this is the pandemic number 2. Now, where did monkeypox come from? I'm gonna ask you this. Have anybody seen the chemtrails lately? I ain't gonna go there on here because they already shadow banned my other page. I don't know. I try to go live on my other page. It's saying everything is enabled, but then they saying I can't go live. I'm shadow banned. But they say community guideline strike, but I don't have no strikes on my community guideline. So you know what it is? I'm telling y'all, one day y'all gonna look up and see me gone off of YouTube. But I'm gonna be on Rumble. That way I'll be able to talk about what I want to talk about with no restrictions to the world. So like I say, where's monkeypox coming from and why is only New York infested so far? You have different sightings. Oh, Atlanta got 2 people. New York got everybody. But I'm looking at this, right? And my sister got it on her page, right? And what she said is this monkeypox mess is really spreading. These diseases are literally dropping from the sky at this point. If you don't listen to nothing I say on YouTube, right? When I'm gone, come follow me on Rumble. But I got a friend. His name is Papa Duck. We both talked about this 4 months ago. We talked about this 4 months ago. When we said that DVOC was only going to be the tester, the Dems' whole goal, you got it. She said, I won't be sharing his sermons. But look, Georgia girl, that's not it. All of my stuff is enabled, green. But I ain't tripping. Because I have pages. Pages. And like I say, and when it comes to the end of the journey for me and YouTube, I will be on Rumble. Y'all come over to Rumble. I'm already on Limpkin. I go live on Limpkin. Actually, I'm going live on Limpkin tonight. Oh, yeah. Oh, yeah. Oh, yeah. I'm going live on Limpkin tonight. So what I'm not understanding is I talk about that tonight. But look, let's get into these motions, man. I talk about that tonight. Let's get into these motions. First motion I'm gonna get into is the government's reply in support of its Santiago proffer and motion to admit evidence pursuant to FRE 801 D2E. That's the first one I'm talking about. I'm actually getting tired of YouTube, really, to be honest. I'd rather go to Rumble and have a great time and do everything on Rumble. Because this YouTube mess is trash. All right. United States of America versus Robert Sylvester Kelly, a.k.a. R. Kelly, Daryl McDavid, and Milton Brown. Government's reply in support of its Santiago proffer and motion to admit evidence pursuant to FRE 801 D2E. The United States of America, by its attorney, John R. Losh, Jr., United States Attorney for the Northern District of Illinois, respectfully submits the following reply in support of its Santiago proffer of evidence supporting the admission at trial of certain co-conspirator statements against defendants and motion for admission of such statements pursuant to Fed REVID 104A and 801 D2E and United States versus Santiago 582 F2D 1128 7th Circuit 1978. Argument: Defendant Brown claims without citation to any authority that the government must identify every single co-conspirator statement and its pretrial proffer. He further demands, without any support in the law, that the government provide 1. The given declarant's identity, 2. The time or date of the declaration, 3. The location of the declaration, and 4. The context of the declaration, noting that the government's failure to do so is extraordinary. However, the government's approach here, identifying certain categories of co-conspirator statements, is a practice regularly accepted by courts in this district. CEG United States versus Barfield. Then it says, accepting the government's Santiago proffer, which did not detail all the co-conspirator statements that were made in furtherance. That were made in furtherance. Hold on. Okay. That were made in furtherance of the charged drug trafficking and money laundering conspiracies, and rejecting defendant's request that the government file an additional proffer specifying the statements. Nothing that a Santiago proffer, after all, is a provisional finding under a preponderance of the evidence standard regarding the existence of a conspiracy and the nature of the statements expected to be made at trial. Nothing in this entry precludes the court's ability to divert from these preliminary findings based on evidence produced at trial. United States versus Marley's case number 15 CR. Same, nothing that, of course, Mirrorless remains free to move to strike these statements if the government fails to meet its burden of demonstrating that the statements are admissible by the completion of its case. The Santiago proffer in this case satisfies the government's burden of establishing a preliminary matter, and by the preponderance of the evidence, the required elements as to each defendant. The types of co-conspirator statements that the government seeks to admit under Rule 801 D2E include: 1. Statements made by and between co-conspirators in the course of collecting and returning to defendants videotapes depicting Kelly engaged in sex acts with minors. 2. Statements made by and between co-conspirators regarding payments received or owed to collect and return to defendants videotapes depicting Kelly engaged in sex acts with minors, or to ensure that co-conspirators would not cooperate with law enforcement. And 3. Statements made by and between co-conspirators regarding polygraph examination concerning certain co-conspirators' knowledge of and efforts to collect and return to defendants videotapes depicting Kelly engaged in sex acts with minors. Additionally, many of these statements are set forth in the body of the government's filing, where the government details the conversations and actions that defendants and their co-conspirators took in furtherance of the charge of obstruction of justice and receipt of child pornography conspiracies. Given the extent and number of such statements in this case, the government does not detail every proposed co-conspirator statement of each witness or document, but rather provides categories of statements to establish by a preponderance of the evidence that defendants and the declarants were members of the conspiracy, and the statements were made during the course and in furtherance of the conspiracy. United States versus Cruz Rib. Okay. Of course, the government is committed to establishing the burglary predicates at trial, and the ultimate admissibility of co-conspirator statements is governed by the trial evidence. United States versus Cox. Indeed, the Seventh Circuit expressly permits courts to address the omission of co-conspirator statements during trial. See Cox 923. Okay. Noting with approval that the district court can rule on each proffered co-conspirator statement as it is elicited at trial based on the evidence the government has adduced to that point. United States versus Alvaro. Defendant Brown further argues that the categories of co-conspirator statements that the government identifies are not sorted by conspiracy, and therefore defendant cannot discern whether the declarants, individuals A, B, or C, and D, were part of the same conspiracy with him, or which statements are admissible against him for purposes of count 6. This argument ignores the paragraph of the government's motion and proffer which set forth the allegations of the count 6 receipt of child pornography conspiracy against Brown, which by nature of the superseding indictment. What is this? Okay. Which by nature of the superseding indictment are related to the conspiracy to cover up and conceal child pornography charge in count 5. Moreover, as set forth in the government's filing, evidence related to the following allegations common to both conspiracies will be offered against Brown. Kelly engaged in sexual acts with minor 1, minor 3, minor 4, minor 5, and minor 6 when they were each under the age of 18. As part of this abuse, Kelly recorded himself engaged in sexually explicit conduct with minors on videotape. During this time, from approximately 1991 to 2014, from at least approximately 1997 to February 2019, Brown was employed by Kelly. Kelly, David, and Brown knew of Kelly's recorded sexual activity with minors, and when they discovered that certain of the videos were missing, they paid others to recover and return certain videotapes, ID'd at 8, 9, 10, 17. Specifically between August 2001 and April 2007, defendants conspired with each other, individual A, B, and others, to receive video 2, 3, and 4. Accordingly, the categories of conspiratorial statements identified in the government's motion and above, statements made by and between individuals A, B, C, and D regarding conversations, activities, and payments related to collecting and returning to defendant Kelly's sex tapes depicting minors, while applicable to the receipt of child pornography conspiracy alleged against Brown. Kelly and McDavid also applied to the conspiracy to conceal and cover up child pornography alleged against Kelly and McDavid, to the extent that any evidence is elicited at trial that should not be considered against Brown. Courts have consistently ruled that a limited instruction will typically suffice to cure any risk of potential spillover prejudice, see e.g. United States versus Thompson. Discussing presumption that that jury can capably sort through evidence and follow courts limiting instructions to consider each defendant separately. Conclusion: for all these reasons, as well as those in the government's proffer and motion, the government respectfully requests that the court accept this proffer and grant its motion. Stop. Let's go back up for a second. So Chuck, Keith, Lisa Van Allen, and Rashona dad, which has passed away, they're using or trying to use against Kelly, Brown, and McDavid. The weird part about this is they said under the age of 18. I think we went over this before, but the legal age in Chicago is 17. So now that they were 17, the government want to call them a minor. But on the federal chart, a minor is 16. 17 is of age. You know what I'm saying? I'm going to say this, and I'm going to say this one time and one time only. Don't come in my chat talking dumb. If you was here to understand what's going on, and you will understand I did read the motion with Larry earlier. But since you coming that way, why your main focus ain't Dabowski? I figured you'll see it my way. So, like I was saying, 17 is legal in Chicago. So now, if you notice, they just moved the needle to a one age up. Why? That's my question. Why? Hit that like button, y'all. Why? You feel me? Why would you move the needle one part up? Now, here come the juicy motion. That's all I'm telling you. Here come the juicy motion. Make sure it's the one. Yep. I never seen a motion like this before. So this one interests me a lot. United States of America versus Roberts versus Kelly, also known as R. Kelly, Daryl McDavid, Milton June Brown, also known as June Brown. Kelly's motion eliminate to bar testimony from government's child sexual abuse expert, or in the alternative, this court must conduct a debate hearing. Whoa. What is that? Let's find out. Now comes defendant Robert S. Kelly by and through his counsel, the Bongine Law Group, PLLC, and moves this court to bar testimony from the government's child sexual abuse expert. 1. The government disclosed that it intends to present testimony from Dr. Daryl Turner to testify on issues related to child sexual abuse. The government contends that it will present Dr. Turner's testimony to show the typical means abusers use to target and groom minor victims. 2. Factors that make children more susceptible to grooming by abusers. Victim dynamics, such as why victims may experience feelings or emotions toward their abusers. 4. Factors that can cause victims to delay disclosure or deny abuse. And 5. Common victim reactions, or so-called victimology. Defendant moves to bar such testimony where Dr. Turner lacks the expertise to testify concerning victimology or victim dynamics. The evidence will not help the trier of fact to understand the evidence or determine a fact at issue, and such expert testimony is not based on sufficient facts or data or the product of reliable principles of the methods and have not been reliable applied. reliably applied to the case at bar. 3. Any assessment of the admissibility of expert witness testimony begins with Fed REVID 702 and the Supreme Court's opinion in Daubert, as together they govern the admissibility of expert testimony. Crack versus ExxonMobil. Expert evidence can be both powerful and misleading because of the difficulty of evaluating it. Daubert 509 U.S. at 595. 4. A witness who is qualified as an expert by knowledge, skill, experience, training, or education in the form of an opinion or otherwise if A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. B, the testimony is based on sufficient facts or data. C, the testimony is the production of reliable principles and methods. And D, the expert has reliably applied the principles and methods to the facts of the case. Fed REVID 702. 5. In Daubert, the Supreme Court interpreted Rule 702 to require the district court to act as an evidentiary gatekeeper, ensuring that an expert's testimony rests on a reliable foundation and is relevant to the task at hand. 6. In performing its gatekeeper role under Rule 70s in Daubert, the district court must engage in 3-step analysis before admitting expert testimony. It must determine whether the witness is qualified, whether the expert's methodology is scientifically reliable, and whether the testimony will assist the trier of fact to understand the evidence or to determine a fact, an issue. In other words, the district must evaluate the proffered expert's qualifications. 2, the reliability of the expert's methodology. And 3, the relevance of the expert's testimony. 8, according to our circuit's president, courts should evaluate the reliability of a qualified expert's testimony by considering, amongst other factors, 1, whether the proffered theory can be and has been tested. 2, whether the theory has been subjected to peer review. 3, whether the theory has been evaluated in light of potential rates of error. And 4, whether the theory has been accepted in the relevant scientific community. 9, in addition to Rule 702, the advisory committee's note to the 2000 amendment outlines other benchmarks in assessing an expert's reliability. 5, whether maintenance standard and controls exist. 6, whether the testimony relates to matters growing naturally and directly out of research they have conducted independent of the litigation or developed expressly for purpose of testifying. 7, whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion. 8, whether the expert has adequately accounted for obvious alternative explanations. 9, whether the expert is being as careful as he would be in his regular professional work outside his paid litigation consultant. And 10, whether the field of expertise claimed by the expert is known to reach reliable results for the type of opinion the expert would give. 10, this list is not exhaustive. District courts are afforded broad latitude when deciding how to determine reliability. In the end, the gatekeeping inquiry must be tied to facts of a particular case and the reliability analysis should be geared toward the precise sort of testimony at issue and not any fixed evaluative factors. 11. Critically, the district court's role as gatekeeper does not render the district court the trier of all facts relating expert testimony. The jury must still be allowed to play its essential role as the arbitrator of the weight and credibility of expert testimony. ID at 780. 12. On February 13, 2020, the government filed a 13-count superseding indictment, charging defendant Kelly with 1. 4 child pornography counts, 2. Conspiracy to obstruct justice in connection with his 2008 state court acquittal, 3 counts related to receiving and the aforementioned child pornography, and 5 additional enticement counts. Counts 1 through 9 of the indictment largely relate to conduct directed at minor 1, while counts 10 through 13 allege sexual abuse of 4 other minors, minors 3 through 6. At the outset, Dr. Turner's credentials and experience suggest he has expertise with evaluating sex offenders, but does not have sufficient experience or specialized knowledge to speak to the so-called dynamics of victims of child sexual abuse. Dr. Turner does not apparently treat child abuse victims and has never published or conducted any research in the area of behavior of child abuse victims. Thus, he simply lacks the expertise to testify about victimology and intuitive behavior, of child abuse victims. Intuitive, okay. 14, importantly, a child abuse expert is of no aid to the trier of fact in connection with determining the issues raised by the first 8 counts of the indictment. The methodologies of abusers and how child abuse victims respond to abuse, it simply is irrelevant to the child pornography counts, conspiracy to obstruct, and conspiracy to receive child pornography. 15, the trier of fact need only decide whether the defendant used a minor to create a visual depiction of sexually explicit conduct. Issues related to whether the defendant groomed a minor and whether the minor behaved in counterintuitive behavior, victim behavior, is entirely irrelevant, since consent is not a defense to using a minor to create sexually explicit content. 16. Similarly, such testimony will not aid the jury in determining whether defendant and his co-defendants obstructed the prosecution of defendant in 2008, or whether their conduct of allegedly securing the return of the tapes constitutes receiving child pornography. 17. As to the inducement counts 9 to 13, a child abuse expert will not assist in trier of fact in deciding the factual issues where consent is not a defense to sexual contact with a minor. 18. With the exception of minor 2, who does not allege that she had sex with the defendant, defendant does not contest having sexual relations with alleged victims in this case. What is largely in dispute is whether these young women were indeed minors at the time of the sexual contact. Thus, wait a minute, that destroys all of their credibility. Wait a minute. What is largely in dispute is whether these young women were indeed minors at the time of the sexual contact. Thus, a child abuse expert has no testimony to offer that is going to help resolve that dispute. 19. Dr. Turner's testimony should be precluded where it is not based on sufficient facts or data, is not the production of reliable principles and methods, and has not been reliably applied to the facts of this case. 20. Notably, the government has offered very little by way of an offer of proof about how it seeks to use Dr. Turner's testimony. The government has offered no report that reflects Dr. Turner's opinion about the defendant's behavior in this case or the so-called victims in this case, because the government does not even seek to offer an opinion applying Dr. Turner's alleged expertise to the facts of this case. It should be disallowed. To the extent Dr. Turner is going to testify about typical behavior of abusers or typical behavior of victims, such testimony is not based on reliable facts or data, but is anecdotal in nature, whatever that means. And anecdotal, okay, in nature. Indeed, Dr. Turner is a clinical forensic psychologist, not an experimental psychologist. He treats and evaluates sex offenders in Louisiana. Dr. Turner himself explains that clinical psychology means testing, diagnosing, treating, making treatment recommendation, consulting with other professionals regarding best treatment for an individual. Dr. Turner's opinions about typical behavior or perpetrator and or victim sees based largely, if not entirely, on his own clinical and forensic practice, which does not provide the type of reliable data contemplated under Daubert. 23. Specifically, Dr. Turner's testimony about typical behavior of abusers. Here we go. Yo, can I get them likes up, man? Can I get them likes up? Significantly, because Dr. Turner has not evaluated. Oh, I'm sorry. I'm jumping ahead of myself. Specifically, Dr. Turner's testimony about typical behavior of abusers and victims has not been subjected to any peer review or evaluated in light of potential rates of error. His opinions are premised on his narrow clinical experience. Significantly, Dr. Turner has not evaluated or even reviewed the statements of any of the alleged victims in this case. He cannot consider alternative explanations for their conduct. To put a finer point on it, Dr. Turner can testify genuinely about delayed reporting of sexual abuse, but he cannot say whether his understanding of delayed reporting has any relevance to the facts of this case. Similarly, Dr. Turner might be able to opine that some child abuse victims deny their abuse even though they have been victimized. But that opinion has no place in this case, where Dr. Turner has no basis to opine whether the victims in this case have denied abuse or why they denied abuse. 24. The government clearly seeks to rely on Dr. Turner's testimony to bolster the credibility of certain minors who the evidence will show were not minors at the time of their sexual relationships with the defendant. Stop. Like I said, us on YouTube, we can read and go by the paperwork. But when you have a lawyer that puts that in there, and Prima, you on it. In other words, the ish in New York not gonna fly. The government clearly seeks to rely on Dr. Turner's testimony to bolster the credibility of certain minors who the evidence will show were not minors at the time of their sexual relationships with the defendant. Ooh-wee. Hey, Larry, I know you're going around saying that he ain't going to make it out of Chicago because it's minors. It's not what Bon Jean's saying. And you know, Bon Jean looked at the evidence. Uh-oh. Uh-oh. I think some people going to start backtracking in a few. If Bon Jean looked at the evidence with the federal government, and if she said they wasn't minors, and she can see that coming in, I know the government can see that they weren't minors. So now this word of mouth. Uh-oh. The government seeks to unfairly rehabilitate their witnesses. Huh? Many of whom never alleged abuse by Kelly until decades after the fact, and some of whom did allege sexual misconduct but never claimed they were minors. Even though the government's expert has no idea what the motivations of these alleged victims were or are. 26. Lastly, delayed reporting of abuse is commonly known today. It is 2022, the era of Me Too and the era of I Believe All Women. Jurors hardly need an expert to tell them that women sometimes do not report their abuse. Conclusion. For the foregoing reasons, defendant seeks an order from this court precluding the government's child abuse expert from testifying. Minimally, a Daubert hearing must be conducted so this court can determine whether such testimony is proper. Respectfully submitted, Jennifer Bonjean. Okay. So in this case that I read earlier with Larry, right? We went through all the speculations and everything. We went through the computers and all that, right? We went through the indictment of Larry, and I'm not going to rehash that with y'all because we already read that a while back, and I don't think it's fair to put y'all through that again. However, I stopped at a certain point, and I didn't go past that. But I want to go past that. I want to go past that because I want to see something. I want to see something. Before I go to the last indictment. 10:44 ain't going to take me long. Okay. I seen something. This last page, right? And I'm going to take it from here. take it from. I'm gonna take it from here. Take it from right there. I wish to advise you, Mr. McGee, of your right to appeal your conviction. Hold on. Wait a minute. U.S. cooperate with the U.S. Probation Office, and Jesus Christ, this thing keep going. Mm. Did this deal with Larry? Okay. Now that's reflected in the base offense level and the amount of loss, but the fact of matter is this is a serious federal crime, and a message should be sent to others and to these defendants that if you engage in the systematic, extensive, long-ranging theft from an insured federal institution, and you are caught, that you are likely to serve a substantial sentence. And my sentence will reflect this. The broad harm caused to the individuals whose credit was stolen, as well as this institution. Now, I should say I credit the government for their explanation about the relative roles of the individuals. I am not sure I fully appreciated it at Mr. Arena's sentencing, but I appreciate it now. That really in the order of involvement or responsibility for this. It's Arena's first, McGee's second, and Mr. Motley's third, to the extent that Mr. McGee recruited him. And I think that's not a particularly favorable thing for Mr. McGee. And that he recruited another individual to the conspiracy and directed him with regard to the creation of these fake bank accounts. So this was a sophisticated fraud, and Mr. McGee was literally in the middle of it. And I think Mr. McGee needs to understand that it's a serious crime, and he's going to have to pay a price for that in terms of some period of incarceration. I understand the defense wants a non-custodial sentence. I understand that's within my authority and power. But I don't think it's appropriate given the amount of money stolen, how long it lasted, the number of people involved, the recruiting of others, and the broad harm that the scheme caused. Overall, I believe a sentence of 18 months, which would result from a 2-level variance downward in light of Mr. McGee's positive characteristics. I would rather vary in this matter down from the level 17 that I previously computed to a level 15. After my consideration of the 3553 factors, and impose a sentence of 18 months. I would also impose that those would be on each of the 2 counts to run concurrently. I would impose a term of supervised release of 5 years. I would impose financial disclosure, new debt restrictions, and self-employment disclosure while the restitution amount remains unpaid. I would order full restitution in the amount of $1,506,393.76 to be paid to Synchrony Bank. That, of course, is subject to any funds received to offset that amount paid by the co-defendants. Okay. That amount representing the amount of the total fraud. So all three of them got to split that 3 ways. That's 500,000 each way. Okay. That amount representing the amount of the total fraud. I would not waive. I would waive fine in this case, rather, because I find that Mr. McGee's financial situation would not allow him to pay restitution, take care of his family, and also pay a fine. It would be unnecessarily punitive and perhaps interfere with his reintegration back into society and support of his family. So I will waive a fine in this case. However, it is required under statute that a total special assessment of $200 be imposed, and I would impose that. There is a final order of forfeiture coming my way, or did come my way, Ms. Murphy. I'm sorry, I don't recall that, Ms. Murphy. It has been submitted to the court. Your Honor, it was sent in yesterday. The court, all right? Any objection to the forfeiture order as submitted by the United States, Mr. Brownstone? No, Your Honor. The court, all right. I'll sign that order. Ms. Murphy, do you know of any legal reason why I can't impose the sentence I have just described? Ms. Murphy, the government is not aware of any legal reason. Mr. Brownstone, no legal reason, Your Honor. Pursuant to the Sentencing Reform Act of 1984, I'm sorry, Mr. McGee, I'm now going to pronounce sentence. Pursuant to the Sentencing Reform Act of 1984, it is the judgment of this court that you, Larry McGee, are hereby committed to the custody of the Bureau of Prisons to be in prison for a term of 18 months on each of counts 1 and 2 to be served concurrently. Upon release from imprisonment, you will be placed on supervised release for a term of 5 years. This term consists of terms of 5 years on each of counts 1 and 2. All such terms to run concurrently. Stop. Upon release from imprisonment, you will be placed on supervised release. That means he on parole. Oh boy. Now I understand. That means Larry on parole, and if Jennifer submits this, that can violate him. Now I understand. Okay. Within 72 hours of release from custody, you must report in person to the probation office in the district to which you are released. While on supervised release, you must not commit another federal, state, or local crime. Oh my God. Must not possess a firearm or other dangerous device, must not possess an illegal controlled substance, and must comply with the other mandatory and standard conditions that have been adopted by this court. You must submit to 1 drug test within 15 days of commencement of supervision and at least 2 tests thereafter as determined by the probation officer. I am going to impose those 3 special conditions I indicated. I do so because of the nature and circumstances of the offense of conviction, the history and characteristics of the defendant, the need for specific and general deterrence, the need to protect the public, and to provide needed correctional treatment to the defendant. I find that these conditions involve no greater deprivation of liberty than is reasonably necessary. Excuse me. First, upon request, you must provide the U.S. Probation Office with full disclosure of your financial records, including common led income, expenses, assets, and liabilities, to include yearly income tax returns, with the exception of the financial accounts reported and noted within the pre-sentence report. You are prohibited from maintaining or opening any special individual or joint checking, saving, or other financial accounts for either personal or business purposes without the knowledge and approval of the U.S. Probation Office. You must cooperate with the U.S. Probation Office in the investigation of your financial dealings and must provide truthful monthly statements of your income. You must cooperate in the signing of any authorization to release information forms permitting the U.S. Probation Office access to your financial records. You are prohibited from incurring any new credit charges. What? Opening additional lines of credit or incurring any new monetary loan, obligation, or debt by whatever name known without the approval of the U.S. Probation Office. You must not encumber or liquidate interest in any assets unless it is in direct service of the restitution obligation or otherwise has the express approval of the court. You must cooperate with the U.S. Probation Office in the investigation and approval of any position of self-employment, including any independent, entrepreneurial, or freelance employment or business activity. If approved for self-employment, you must provide the U.S. Probation Office with full disclosure of your self-employment or other business records, including but not limited to all the records identified in the probation form 48F. Requests. Oh, you're not on parole, you're on probation. Okay. Requests for self-employment records or otherwise requested by the U.S. Probation Office. I'm going to scroll down because it's a lot. That's a lot. Jesus. So now I understand. But I want to get to this part. Where is that? Mr. McGee, where you serve your sentence is entirely up to the Bureau of Prisons. I will recommend, however, that you serve at an appropriate facility in the state of Nevada, as close as possible to your home address. Jeez. All right. Is there anything else the United States wishes me to address at this time? Nothing. All right. No. Okay. Nothing. No counts to be dismissed. All right. Mr. Brownstone, nothing for the judge. Court. All right. Thank you for that. Mr. McGee, you came from humble beginnings and have worked very hard, pursued some education. Perhaps you will pursue some more. You strike me as an intelligent man who has a great amount of potential, and you've demonstrated that over the last couple of years. You did the right thing in this case, and you're trying to do the right thing in your community. I think you have a bright future. Nothing in my sentence is designed to discourage you from achieving great things. It's meant to convey to you the seriousness of what you did. I think that's something that's not lost on you. I've tried to balance the good person that you are and the things you've tried to do and the cooperation you provided to the United States. What cooperation? I wish you good luck in the future. All right. If there's nothing else from the parties, this matter is concluded. I wish you all a good rest of the day. I've tried to balance the good person that you are and the things you tried to do and the cooperation you provided to the United States. Bro, are you serious? This right here is all Bonjean needed to see. Mm, mm, mm. That right there, that line right there is going to spark everybody's interest. What did he cooperate? And the cooperation you provided to the United States. That's deep. Jesus Christ. That's deep. So they say a video come with this, and when I look at it, it do show a video when I downloaded the transcript. I want to see this video. Hold on. I want to see this video. Oh, snap. Oh, snap.
We did our job. We brought the information to the public. Surviving R. Kelly went off, we kept that shit going. We got bus drivers, we got police officers, we got assistants, we got friends, we got people to lie, we got the stories, we got motherfucking video, audio. You have seen Asriel at my house, you have seen parents at my house. We've done it all. I prove you that every single person that was around him, that go on them fucking channels, have talked to and communicated with the feds, and they are 100% going to tell him, I don't give a fuck if it's Kip, if it's Don, if it's whoever else. I ain't gonna name them all the motherfuckers, the white girl, all fuck. We did our job. We brought the information to the public. Surviving R. Kelly went off, we kept that shit going. We got bus drivers, we got police officers, we got assistants, we got friends, we got people to lie, we got the stories, we got motherfucking video, audio. You have seen Asriel at my house, you have seen parents at my house. We've done it all. I prove you that every single person that was around him, that go on them fucking channels, have talked to and communicated with the feds, and they are 100% going to tell him, I don't give a fuck if it's Kip, if it's Don, if it's whoever else. I ain't gonna name them all motherfuckers, the white girl, all fuck.
Yo, I thought this was an audio. I didn't know it was a video. Larry, are you crazy, yo? I thought this was an audio that somebody, because the way it came to me, somebody said that the Boski put it out and it was an audio. This a video, man. If Bonjean got this, there's no telling what else she got. Dog, man. I hate to do this to my boy, but you gotta lawyer up, bro. You gotta lawyer up. Because they coming for you. And right now,
this is not the type of tea I want.
It's over for you.
This is not the type of tea I want.
It's over for you.
I'm just saying, bro. That don't look good. This is crazy. I'm thinking this is an audio because I hear people playing it. But this is an actual goddamn video. Like, how did they... Like, how's bump... At the end of the day, I've been said this shit, man. At the end of the day, I clearly say it's their job to investigate. Right. I said this shit, man. Do not run to this shit, man. Nobody. This ain't something that motherfuckers want to run to. Yo, that's facts, coach. That's facts. Yo, just off that, yo, you, man, oh my God, bro. Well, I said it once and I say it again. If you did something wrong and you broke federal law, you got to suffer the consequences. That go for me. That go for Levi. That go for Bedbug. Go for Larry. That go for everybody. If I violated a federal law, I'm going to jail. I doubt if I ever go to jail because I ain't violate shit. Only thing you might get me on is terroristic threats to somebody. Go do it. I never attack nobody unless you attack me first. Who's this saying that? Faces and Beyond. At the end of the day, man, it's crazy. I'm thinking that's a audio. That's a video. So if she got that, it's no matter what else she got. There's no telling. And she might just put that out there just to say, look, I'm going to give you this small little piece of the pie. But the thing about it is, my guy got booked off of that, though. That's not cool, man. That's not cool at all. And then it's... See, I don't want to watch it no more because I'm going to go deep into it. That's not cool. I'm thinking somebody done chopped and screwed and put some stuff together. And goddamn, this is a goddamn video. Man. Hey, at the end of the day, you said it. You got to deal with it. I'm going to play it one last time because I just can't believe I heard that. I can't believe I heard that. I can't. Larry, you got some explaining to do. You got some explaining to do. I can't believe I heard it. I can't. Yo.
We did our job. We brought the information to the public. Surviving on R. Kelly went off. We kept that shit going. We got bus drivers. We got police officers. We got assistants. We got friends. We got people to lie. We got the stories. We got motherfucking video, audio. You have seen Asriel at my house. You have seen parents at my house. We've done it all. I prove you that every single person that was around him that go on them fucking channels have talked to and communicated with the feds, and they are 100% going to tell him, I don't give a fuck if it's Kip, fuck if it's Don, fuck if it's whoever else. I ain't gonna name them all motherfuckers, the white girl, all fuck.
But you wanna know the crazy part about that? Did you really want to know the crazy part about all this? What you just did, Larry, with that, you just put yourself against Asriel, because now they're going to question Asriel. And now there's going to be Asriel versus Larry. That's not going to be a good look. Man, I don't know why you're trying to spam my fucking channel. Damn, and it's quite funny that we get to talk about that, and now you want to spam my channel. Who the fuck are you? Yo, this gonna put Larry versus Asriel, because they're gonna pull Asriel up and like, wait a minute, and you was at this person, and then they're gonna pull Angelo up, and then you know Larry and Angelo, they've been beat. This shit about to be terrible. There's a lot more motherfuckers about to go to jail. This is about to be terrible. So now, here come the infrastructure fighting with Team Truth. Team Truth versus OCOV. And here we go. The problem is, Team Truth side got the star witness of New York. And it don't look good on Oko's side because their leader just got on, their leader still on papers. So I'm sitting here like, shit, I'm not getting in it. That's none of my business. I'm just going to watch from afar. This is crazy. And to see that Jennifer went to this level to pull us out, you can't say you can't say she picking on you now. You can't even call her a terrorist as you did. You can't do none of that. Because you said it. These are your words. Man. I'm about to put my motherfucking glasses on and sit up under the shade and look like this. This is about to be a battle for the... Yo, this is about to be real ugly. And man... I don't know. But I do want to address this much. And I'm going to go here. I am Queen Newton. Check it. And I am going to address Okov. Because I'm Dream Team through and through. And I'm the leader of the Dream Team. What you did today, I am Queen Newton, is not cool. We don't come to Larry Page. We don't come to Tia's page. We don't come disrespecting none of y'all. Whatever y'all believe in, that's what y'all believe in. When we go to Diva page, we show the utmost respect. So when you came to I Am Queen Newton page, I Am Queen Newton, when you came to Alicia page today, you made it your business to ask who else do the Dream Team? Who do we what is the word I'm looking for? I'm looking for that word. It's on the tip of my tongue. Who do we advocate for? Who else do we advocate for? You put me in a position where I don't want to be. Because you know I go all the way to fuck in. And I'll lock in. So I understand, and the ladies of the Dream Team got you all the way together. But I'm going to ask you this question. Before Angelo came to YouTube, who was y'all advocating for? Because truth to be told, the story that y'all came on the scene with is not the story that y'all following with. So at the end of the day, if the ladies over here want to say free R. Kelly, that's what they want to do. When y'all was saying keep him locked up, give him 172 years, we sat back and I held everybody at bay. I said, nope, let them have it. Because they wanted to tear your ass apart then. I said, nope, let them have it. Let's see. But now you playing a dangerous game. And if you understand anything about lionesses, they hunt first. Please don't do that no more, I Am Queen Newton. Because that's going to create an unnecessary beef and an unnecessary war. Y'all already have a war arising with Azriel and the Claries. Y'all got a war on a arising with that. If you can't see what's coming over the horizon, you don't need to be nowhere near the you don't need to be nowhere near the herd or the cattle, because you're going to be the one to get somebody hurt. So at the end of the day, when the Dream Team ladies doing what they doing and they going live, they ain't bothering nobody. They talking about the injustice that was served to Robert Sylvester Kelly. Now, the problem that I'm having with this is that I watch Hambone fuck over people so much. And when niggas get on her retarded ass, she run and hide behind Tune, Atmos, Robert Keller, Larry, and all of them. I've been keeping my mouth shut for a reason about that. That shit ain't gonna work no more, man. Now, we ain't trying to have no beef with nobody. But I'm from Baltimore. And we got a motto and a war song. And when that war song go out, it's going to be war. So let's prevent that. Because what you doing was very bogus and very dumb today. That's very bogus and very dumb. To really try to pick a fight with the strongest faction on YouTube. That's dumb. Let's not do that, man. What y'all need to do is try to find a way to try to curb this thing that's going on now with y'all leader. Instead of y'all worrying about people supporting Robert Sylvester Kelly. And I'm only giving you sound advice. I ain't even coming at you, rah-rah. I'm giving you sound advice, because what you're doing is you doing adolescent things, and I'm quite sure you older than me. Don't do that. Because the next time I won't be coming here to talk. The hound's going to come loose next time. And once again, we ain't trying to beef with nobody. We putting facts out there as they come out. We've been putting facts out there, and we put it out there as it is. The indictment is nothing but an opinion. But if they investigating that shit and they pulling shit like that out, I ain't trying to beef with nobody. I'm trying to keep my head on the fucking swivel. Because at the end of the day, what y'all fighting ain't nothing to play with. Let's keep it a buck. Larry could be gone for 20 years. If this pan out like they trying to make it pan out, he's gone. And that's fact. So instead of all that dumb shit that y'all doing, y'all need to rally around y'all leader and try to find out exactly what the fuck going on. Because I looked at his live from last night. And I don't care what nobody say. I don't even care what Larry say. I know Larry better than a lot of you motherfuckers over there. That nigga was scared. And I ain't gonna lie. If I was in that seat, I would have been scared. Honestly, that would have been the last time y'all heard from me in a while. I would have said, fuck all y'all. Because now you playing with freedom again. That ain't something that I want to gamble with. So at the end of the day, I understand you might want to get a rivalry going, but what you did today is not the way to do it. Because trust me, where there's one, there's about 5 of them that's sitting waiting. I had to go back and look at the chat. I said, oh my fucking God. I had to look at it like, is this what they on? Nah. I understand baby Limp out there on the West Coast. She can't help herself. And I heard her talking about me. But sweetie, let me introduce you to Dana. The vagina that I've been had that I forgot about, you can't get the dick to match up with it. Let that be known, Ty. So while you're in your wheelchair trying to find your vagina, bitch, just know that I got pussy that I can loan you. Because you can't even wipe your own ass. So let that be where it's going to be. Ty, you can't even boil water. So why am I arguing with you? I don't. I let you say what you say on these little platforms. I get it. Don't no man want you. Glenda showed the video of me eating her old homegirl pussy. You got hot and bothered. You seen a picture of my dick 2 years ago and you want it. Every time you turn around, Dana this, Dana that, Dana this, Dana that. I wouldn't slap my dick on your face, bitch. Understand, I need a woman with motion. You can't move. Your legs are hanging. They dangling. You need a wheelchair to get you around. What the fuck I'm gonna do with you? But you the messiest motherfucker on YouTube. You create fake pages along with the mother motherfuckers. You go in and you email motherfuckers and make it seem like it's from somebody else. And then when somebody get on your ass and you run to the niggas over there. But them niggas can't save you over there. And understand what I'm saying to you, Ty. I'm letting you live. Meaning, I could have been came out and destroyed you on YouTube. I choose not to. I don't take pleasure in that shit. Shit, if I really want to get to you, I take your batteries out of your motherfucking walker and make your ass push that bitch. I go get your battery pack for your wheelchair and throw it in the river. Stop playing, man. You've been through too much to be that fucking messy. That shit ain't cool. If you don't like somebody, leave it at that. Don't fuck with them. But I ain't in high school no more. I ain't in elementary school and I ain't in middle school. Don't try to pick on me because you like me. I don't give a fuck about that. I fuck with women. That's all I'm saying. So that shit that you talking, man, yo, stop that, yo. Stop that. Stop that. And that's why Diva stay in so much shit, because she be defending you. And that's not fair to the motherfuckers that do defend you, because you be starting that shit. That's not fair. Motherfuckers need to let your ass sink in your shit. That's some fucked up shit about you, man. And when you started this beef between me and you, I get it. I know who's pushing your buttons. I know who got the battery in your back. But guess what, bitch? I will pull that battery out and throw it at the motherfucker for that motherfucking put it in your back. I'm not that guy no more. That for that nice Dana, that yo, stop, yo. I can be the coolest motherfucker out here, but don't play with me like that. And as far as and with you, you can't come back from that no more. You can't come back for the shit you did. And then you're gonna try. Well, Dana, it's not that serious. It is that serious. It is that serious. What if I started a rumor and said what if I said some midgets and some junkies held you down and they all took turns raping you in your mouth? Would you like that? What if I say for the reason why and you got that lingering piss smell is because some niggas hit it from the back and you couldn't even wipe yourself after they were finished and they nutted in you and they burnt you? And you wouldn't like that, would you? And I just made that shit up as it went along. Yo, don't lie on me, yo. Even though it's funny. Because truthfully, you want to fuck me. So I get it. All of y'all to talk about, oh, Dana gay, Dana this and this and this. Was I gay when you was fucking with me, or was I gay after I stopped fucking with you? Make it make sense. Because if I was gay, you ain't never expressed it to me. Because technically, I would have told you, where's your mama? I will fuck your mother in front of you and show you how gay I am. But then I'm going to get biblical and I'm going to get knowledgeable on you. Technically, everybody is gay, definition number one, which means they're happy. Make that make sense. Don't let it fly over that wig you got. On that note, I got one more thing to talk about, and I'm out. And like I said, there's no beef. I just got to make sure that shit ain't going the way they trying to make it to go. Now, last but not least, for the people that wasn't on the call, And for the people that was on the call and they couldn't hear it, here's the update. The Honorable Hector Gonzalez, United States versus Christopher Gunn. Dear Judge Gonzalez, the government submits this letter to advise the court of new information relevant to the bond revocation application currently pending before the court. See ECF number 12 on July 28th, 2022. The government learned that on or about July 26, 2022, 2 days before the scheduled status conference before this court, the defendant narrated a video which was live streamed on YouTube on the Bolsky Gun YouTube account. The video. In the video, the defendant states, in sum or substance and in part, I am going to make y'all motherfuckers pay. And I don't care how long it takes. I'm going to get you motherfuckers back. And I'm going to get you back in real time. In another portion of the video, the defendant states, you better hope they keep me on this leg monitor for life. You better hope they keep me on this shit for 50 years. The defendant also says, the next time you hear from me, I'm going to be in some fucked up shit. In addition to violating the conditions of release, which require that the defendant refrain from contact with any person who is or may be a victim or witness in the investigation or prosecution. The video and demonstrates that there is no condition or combination of conditions that will assure the defendant will not pose a danger to the safety of any other person or the community. See Title 18, United States Code, Section 3148. Then it says July 26, 2022, video will be provided to the court under separate cover. For the foregoing reasons and those set forth in the government July 28th, 2022 letter, CECF number 12, the government joins pretrial services and respectfully requests that the court revoke the defendant's bond and detain the defendant pending trial. However, let's go here. He wasn't detained, but they did take internet access from him. You know what I'm saying? But they did take internet access from him. And they did take anything communicating with the outside from him, and he can't come outside. However, as we seen today, that operating his account is T-Baby. As we seen, I'm gonna leave that there. However, I don't think people understand how serious this is. I don't think they understand how serious this has gotten. The worst thing she could have did is went live from his account and not shown who was with her. The reason why I say that is because now any narrative can fit. You would normally go live and you would show, even if you had a mask on. Why go live and not show now unless you had somebody with you? There's too many instances in that live that point to they were together. But that's none of my business. That's none of my business. However, when I think about my child being on a dildo, that's all of my business. When I think about my son mom being harassed to the point where all of them is believing the lie and sending cash apps for Christian and this, that becomes my business. I got it. On that note, DanaJay up out of here. Y'all be blessed. Don't forget, y'all continue sending the $45 pledge. 3 people has donated so far or pledged so far. I need 62 more people with the $45 pledge in between now and Saturday. Okay? All right, y'all be blessed. We all gonna link up tomorrow afternoon. I'm gonna send some uploads your way. But be blessed again. DanaJay out. Peace.
This is not the type of tea I want.
It's over for you.
This is not the type of tea I want.
It's over for you.
Swimming in you. Hey, little mama. Said I wanna take her. Dipping your pool. Just go for a little dive, yeah. Hey, yeah, yeah, yeah.
Wow.